All right, let the record reflect the state's attorneys present, defendant, and defense counsel are present. I have received a message that the jury's reached a verdict. If you can please bring the jury in. All right, let the record reflect the jury is seated. State's attorneys present, defendant, and defense counsel are present. At this time, I would ask the foreperson, has the jury reached a verdict?
Yes.
And is it the unanimous decision of all of the members of the jury?
Yes.
Thank you, sir. You can hand it to the bailiff. Mr. Radford, Mr. Freeman. We, the jury, find the defendant, Joseph Charles Freeman, guilty of murder as charged in the indictment. You can have a seat. Does either party wish to have the jury polled?
State does not. No, Your Honor.
All right, so ladies and gentlemen, at this time, I accept and receive your verdict finding the defendant guilty of the offense of murder. And what that means is that that first phase of the trial is over. We'll move to the second phase, which is the punishment phase. It's 5 minutes to 12. You guys have been working all morning. Also, we're going to take just a little lunch break, maybe a little bit longer one, so that we can have the attorneys get ready for the punishment phase. We'll also work on that corpse charge, so it'll be ready at the right time. You get another one of those in the punishment phase. You're still under all of the instructions that you were previously given. I think I'd like to get started at 1:30. So that gives you about an hour and a half, and we'll stay and get some work done. Mr. Coleman, Mr. Radford, any objections to me releasing the alternate at this time?
No, sir. No, ma'am.
We thank you for sitting and waiting out there, sir. Now that we've gotten to this point, you are going to be excused from any further service. We really do appreciate you. If you need anything for your employer, you can ask the bailiff on your way out today. Have a great rest of your week. And for everybody else, we'll be in recess. If everybody else would remain seated, you're excused until 1:30. All right, let the record reflect the jury's outside the presence of the courtroom. I will also at this time revoke any bond that has been set in this case. I don't know if there's a bond set or what it is based on.
She's got a TDC hold. So.
I know, I'm required to do that. So if there is a bond on this case, I'm going to revoke that. So with regard to punishment, I do have a draft that I can get to you guys real quick. And I'll let you look at it and you can kind of let me know if you anticipate. It's just the very basic, nothing extra. I don't know if there's going to be any evidence with regard to extraneous offenses, if I need to add that in.
Just prior criminal history, Judge.
Okay, so I don't need the convictions. Do I need an instruction on I wouldn't think so. Anyway, y'all look at it. Hold on, I just emailed to myself and I don't see it, so let me get.
No, if he's not gonna put on any extraneous offenses, I don't think we need an extraneous.
Just prior judgments is I'll anticipate.
Okay,
No, that's, I think.
well, maybe I didn't hit send. I don't know where. Hold on. All right, we're gonna go, we'll be in recess.
One other thing on the record for the jury.
Yes. So let the record reflect the state's attorneys present, defendant, defense counsel are present. You guys have both been given a copy of the court's proposed charge. Obviously, if anything else comes up, we can add, but did you find any? I just realized that at the very first sentence,
It didn't have the offense in there.
I just changed that. Is there anything else that either of you?
It's very vague. I think we got this issue in the last trial, page 4, that the paragraph begins with under the law applicable. That last sentence,
Oh,
second to last
yes.
sentence, I don't know that we need that in there.
You're right. I'm
Talks
taking
about
that.
less than 4 years.
The next to the last sentence I'm taking out because it's just confusing. You see that, Chip?
Yes, ma'am.
But the eligibility for parole does not guarantee parole. That,
And I think that makes.
yeah.
Oh, somebody's. Y'all hang on just a second.
And all right, you have.
Thank you.
And I'm advising you that you not testify to remain silent. Do that.
Thought about that.
Judge, I just need to put his assertion of his Fifth Amendment right on the record.
Okay,
Just
hold on.
clear, Judge, you're leaving in that last sentence, it says eligibility for parole does not guarantee parole is granted.
Yes.
That's all I have. It seems, am I missing something? It seems a little short, like, is it because we don't have probation in there?
And there's no probation, there's no enhancement
Okay,
and things like that, to find priors true and all that kind of stuff. That's usually what makes them long. A standard, we don't have them very often, but they're very short. I think everything's in there. With regard to the charge, Mr. Rafford, anything? Right.
Nothing we hadn't argued with.
All right. And so you need to put something on the record?
Yes, ma'am.
Go ahead, sir.
Mr. Freeman, you understand again that you have a right to testify
Yes, sir.
in the punishment phase of the trial. I'm advising you that you should not testify at this phase of the trial. Do you agree with that?
Yes, sir.
All right, that's all I have, Judge.
Thank you. And was there any issue you guys had come to the back with regard to some potential?
He showed me it's innocuous, Judge. I don't have a problem.
Okay, perfect. Thank you. And Mr. Coleman, I'm going to need your signature on this discovery certification. Please, sir. All right, then. Anything else before? Thank you, sir. Anything else before we bring the jury in?
No, ma'am.
All right, we can bring the jury in, please. I need the witnessing. Is it in? It should be on the waiting list. There it comes. I think you've got to click it. Whatever.
Ladies and gentlemen, very briefly, you now know that Freeman already was convicted of aggravated robbery on a plea of guilty out of this court and is serving a 60-year sentence. I would submit to you that he is a young man. I would ask you to take that into account when assessing his sentence in this case, and also the fact that he was not the shooter. Thank you.
Thank you, Mr. Radford. Mr. Coleman?
thank you, Your Honor. Make these court, Mr. Redford. Ladies and gentlemen of the jury, I will likewise be short and brief with my remarks to you, but I would be remiss if I didn't begin by thanking you on behalf of the DA's office and on behalf of Richard Shiloh and also on behalf of our community, especially our community. You get the opportunity today to be the voice for our community. You are all acutely aware of the issue or issues that we have with guns and gun violence. You get the opportunity to say by your verdict what we think and how we feel as a community about these types of offenses. It matters. These jury verdicts matter. They matter in a couple of respects. It matters as it relates to this defendant for sufficient punishment. It matters for the family of the victim when they look back on this 3 years from now, 13 years from now, however long. Your verdict says to them exactly what it meant to you. The loss meant to you as a member of this community. But it also sends a message to the other individuals who are sitting in the jail right now or who would consider to do this type of offense. It matters. It makes its rounds on the social media. It makes its rounds in the jail. Believe it or not, your verdict and what you give out in the way of a punishment will make its way back to the jail before you get off that elevator and go to the parking lot. It's funny how that happens. It matters. So I'm asking you to consider that in your verdict, the deterrent effect that your verdict will have. Just a couple of things in the jury charge I want to point out. I want to do something for you, and hopefully it shortens your time in your deliberations. And I have no doubt that you were thoughtful during your guilt innocence deliberations and deliberate. And I trust that you'll do the same thing during the punishment deliberations. But I think I would hope that you, like me, think that, wow, this is terrible, it's horrible. There are worse crimes that merit a life sentence. So I would submit to you that you start by crossing off the life, maybe even cross off anything on the higher end, toward 80 or 70 years behind bars. But on that same spectrum, on the low end of the 5 years, I think the 5 years should be reserved for someone who has little to no criminal history. You've heard this defendant's criminal history. He was given an opportunity for probation on that felony evading arrest case. And how does he respond to that by going out and committing an aggravated robbery against two different individuals at gunpoint. That to me is telling. There is a component there of not being rehabilitated or rehabilitatable that you should consider. So I think that merits something higher than the low end of the punishment range, whatever you deem that to be. And then another thing I'd ask you to consider is the circumstances of the offense. I tried to make it a point to ask the witness or witnesses about the park that was adjacent to that apartment complex. Who knows where bullets and ricochets and rounds could have ended up? Who knows if someone would have inadvertently, pointed a gun? Who knows if as they run away with those guns, if a round could go off and heaven forbid injure one of those children. This is why people are concerned about going out in public and going to places in and around Beaumont, in and around Jefferson County. This was a day, an afternoon, a regular day where people were at that park and look what they had to encounter. So I ask you to consider that. Nothing on the high end, no life, no 80, no 70, nothing. But certainly, I don't think this case merits something on the low end, 5, 10, 15, So I'd ask you to consider something in the middle, and I have no doubt you get it right because you got it right with the guilty and the innocence. Another thing, don't consider a fine. People get back there. If the fine is even ever paid, it will not go to the family of the victim or anything. Who knows what the state does with it. So what I don't want you to do is get back there and waste time deliberating and trying to come up with a number on the fine. So, also, I'll close by talking about the parole law. There's a paragraph in here, and I'll encourage you to read it about the parole law. There is a possibility that this defendant will be eligible for parole after serving half of whatever the sentence will be. You can't guarantee that. You can't. Technically, that's not something that you can. Let me just read it. I don't want to get it wrong here. You can't accurately predict how the parole laws will be applied to this defendant. So don't try to predict how they will be applied to this defendant. But you can take into consideration that there is a possibility that after half of whatever your sentence is that you give, there could be possible. So with that, ladies and gentlemen. Again, thank you for your time. Thank you for your attention. And I have no doubt you get it right. You got it right the first time. So thank you.
Thank you, Mr. Coleman. All right, ladies and gentlemen, you've heard the evidence, the court's charge and closing argument. Again, I'm going to get the bailiff will take the charge and get you situated in the jury deliberation room, and we'll be in recess until you reach a verdict. All right, let the record reflect State's attorneys present, defendant and defense counsel are present. The jury has sent a note that they've reached a verdict. You can bring the jury in, please. All right, let the record reflect the jury seated, State's attorneys present, defendant and defense counsel are present. At this time, I'd ask the foreperson, has the jury reached a verdict?
Yes.
And is it the unanimous decision of all of the members of the jury?
Yes.
Thank you, sir. You can hand it to the bailiff. Record. We, the jury, having found the defendant, Joseph Charles Freeman, guilty of the offense of murder, assesses punishment at imprisonment in the Texas Department of Criminal Justice for a term of 60 years and no fine. You can have a seat. Does either party wish to have the jury polled?
Your Honor, the state does not, and I would withdraw my motion to accumulate sentences.
Thank you, sir. Do you wish to have the jury polled?
No, ma'am.
Is there any reason at this time not to pronounce sentencing?
No.
Sentence. Right, then at this time, Mr. Freeman, in conformity with the jury's verdict, I sentence you to a term of 60 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You've been handed 2 documents. The first is the trial court certification of your right to appeal. Mr. Radford will go over with that and explain what your rights to appeal are. The second is a written admonishment regarding your ineligibility to possess a firearm or ammunition. We've gone through this before. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right. So at this time, you will be remanded to the custody of the Jefferson County Sheriff's Office until transportation to the Texas Department of Criminal Justice. And so I'm going going to go ahead and have the bailiff bring Mr. Freeman back. Ladies and gentlemen, I'll come visit with you in just a minute and discharge you all from everything in just a second. Thank you, Mr. Coleman. Thank you, Mr. Radford. And court will be adjourned, and we'll have you guys exit the courtroom, please.
This is where the punishment hearing takes on even greater legal significance. Prosecutors are introducing certified records and fingerprint evidence to connect Joseph Charles Freeman to prior felony convictions, including aggravated robbery and evading arrest. Under Texas law, a defendant's criminal history can be considered by the jury when determining an appropriate punishment after a guilty verdict. These records are not being used to decide guilt for the murder charge. They're being presented to help the jury evaluate the proper sentence. Do you think a defendant's past convictions should heavily influence punishment in a new murder case? Keep watching, because the attorneys are about to make their final arguments before the jury decides the defendant's future.
Those records, who do they pertain to?
They pertain to Mr. Joseph Freeman.
And how did they come into the possession of the Jefferson County, or how were they generated by the Jefferson County District Attorney, Jefferson County Sheriff's Department?
They're created through the routine intake process. Anytime somebody comes in, it's files we generate whenever they're brought into custody.
And when you say coming in, you mean when they're arrested, right?
Yes.
And when someone is arrested or quote unquote booked into the jail, certain information related to that individual is gathered and maintained by the Sheriff's Department, right?
Yes.
That information includes what?
Name, date of birth, driver's license number, state ID number if they have one, fingerprints, mugshots.
And you brought with you here today those types of identifying information for an individual named Joseph Freeman, right?
Yes, sir.
May I approach the witness, Judge?
Yes.
Take a look at those documents, please. I am going to hand you what I've pre-marked as State's Exhibit number 85. Are those are 8 pages of documents. Are those true and accurate copies of the documents, other than the redactions that we made for trial today? Are they true and correct copies of the documents maintained by the Sheriff's Department as it relates to an individual by the name of Joseph Charles Freeman?
Yes, sir.
And you, as a custodian of record, by virtue of your employment, have access to those records, obviously, because you brought them with you, right?
Yes, sir.
And those records were created and maintained in the ordinary course of business for the Sheriff's Department, correct?
Yes, sir.
Your Honor, at this time, State Officer states 85, and they've been previously tendered to defense counsel, and I'll tender to him again.
I don't have an objection, Judge.
States 85 is admitted.
Captain Ponder, let's just kind of run through States 85 there real quick. I guess what I'll do is I'll use the copy, and you can keep that marked copy. That first page there, what are we looking at?
That is a fingerprint card from whenever Mr. Freeman was fingerprinted upon intake.
Okay, and the name that appears there in full, what's the name?
It's Joseph Charles Freeman Jr.
Okay, there is something there that's referred to as a state identification number, correct?
Yes, sir.
And in short, the people in the law enforcement community they also refer to it as a SID number.
Yes, sir.
And for the record, that SID number is what?
It is 1950332.
And is your understanding of the SID number or state identification number, do you understand it to be unique to each individual?
Yes, sir.
Okay. Not unlike a driver's license number or social security number, right?
Yes, sir.
Is there a date of birth there that's reflected as well?
Yes.
What is that?
It is May 3rd, 2003.
And then we've got other information contained in these 8 pages, but is it fair to say essentially it is other identifiers or identification related to an individual by the name of Joseph Charles Freeman?
Yes, sir.
And I want to direct your attention to maybe the second to last page there, this page.
Yes, sir.
What is that?
That is a photo of Mr. Freeman.
A photo taken at the time of at least one booking or arrest?
Yes, sir.
Could you hold it up and show it to the jury? Do you see an individual in the courtroom here today that resembles that individual in that booking photo that you have just displayed to the jury?
Yes, sir.
Could you please point to him and identify him by an article of clothing that he's wearing?
It's a gentleman in the black jacket.
On my right here,
Yes, sir.
Your Honor, I asked that the record reflect the witnesses identify the defendant.
The record will so reflect.
I think those are all the questions I have for you, Captain Ponder. Thanks for being here today. Appreciate it.
One question.
Thank you, Mr. Bradford. Any objection to Captain Ponder being excused?
Right.
Thank you, Captain. You're excused. And Investigator Hinton is still under oath from before. You can have a seat, sir.
Yes, ma'am. Investigator Hinton, would you please state your full name for the record?
Stephen Hinton.
And the jury will recall you from your prior testimony and your role with the district attorney's office as an investigator. In addition to being an investigator, are you also trained with regard to fingerprints?
Yes, sir.
And when someone receives a conviction and it's memorialized in what we call a judgment, oftentimes does that come with a fingerprint?
Yes, sir, they do. Normally the right thumb.
But that's not always the case, right?
Yeah, it's not always the case, depending on the rural areas where it may come from and then the quality of the print itself.
That was my next question. Even if sometimes those judgments have a print on them, they're not always, the quality is not the best, right?
That's correct.
And why?
Can you pull that microphone down and speak a little bit? Thank you.
Thank
Go
you,
ahead.
Judge. And why would that matter to you or in this context?
I think the goal and the objective is to look at prior convictions and compare the prints to determine that it is and it does belong to the defendant in this case, so that nothing is interjected in there that would not belong to him.
Okay.
That's protection for him.
Okay. Now, the prints are not the only way, the allowable way to essentially link a judgment or prior conviction to an individual, right?
No, it's not.
What are some or what are other ways that an individual can be linked to a previous conviction?
You can use an individual's name. You can use a state identification number issued by the Department of Public Safety. You can use a date of birth to still continue to cross-reference and verify that it is one and the same.
Very good. Let's go back to the fingerprint. The jurors, I'm sure, have a notion based on their life experience and what they may have seen on TV about what a fingerprint consists of. But in your training and experience, what is a fingerprint?
It's scientifically speaking, it's friction-ridged skin. It appears on your fingertips, on the palms of your hands, and it's also on the sole of your feet.
And is it unique? Are those prints unique to each individual?
They're very unique and distinct per individual. No one's ever been found to have the same print.
And are you able to take an inked print and compare it to a print that's on a judgment?
I am, yes.
In fact, did you take an inked print of this defendant in this case?
I did.
What is an inked print for the benefit of the jury?
It's where you apply an ink type substance on the friction-rich skin itself, and then you would roll it or you would stamp it on the paper so you could compare it to whatever the, in this case, previous convictions or judgments. You can compare it to the prints that are on those documents.
Did you bring that inked print with you today?
I did, yes, sir.
May I approach the witness?
Yes, sir.
I got ahead of myself. Yeah. Box. Simply not important here. Your Honor, I'm going to be out of order on my evidence on my exhibit labels here,
It's
but
okay.
I'll work it. I'll come back around. I am marking this as state exhibit number 89, and I'll go back to 86, 87, 88 later. When did you obtain this inked print from the defendant?
It was about 12 o'clock, 12:15
Does
today.
it appear to be in the same condition as it was when you first obtained those inked prints?
Yes, I got the date and then my initials on it. I put defendant's name, SID number, date of birth on there so it wouldn't get mixed up with any other prints.
And it doesn't appear to have been altered or manipulated in any way?
No, sir.
State Officer States 89, judgment tenure to defense not to close inspection.
No objections.
89 submitted.
Investigator Hinton, what did you do with State's Exhibit number 89 after you obtained it?
I compared them to the 10 packet, 10 finger packet from the county jail and verify that they are one and the same. And then I started looking at the documents itself, prior judgments to compare the prints.
The 10-finger packet that you're referring to, would that be the documents that were brought over by Captain Ponder that are now in evidence marked as State's Exhibit number 85?
It appears to be from this distance, yes.
I'm having it very closer. Madam Clerk.
Yes, sir.
Yes, sir, that's it.
Okay, and so just to be clear, you've compared your inked prints to the prints on file with the Sheriff's Department, and what, if any, determination did you make?
That they were one and the same. The SID numbers match, the date of birth match, the names match.
Okay, so once you've taken your inked prints in States 89 and compared them to the known prints in States 85 from the Sheriff's Department, what did you do with that information then?
Then I started to compare those with the judgment documents that are provided.
And did you obtain or come into possession of certain prior judgments that you believe belong to this defendant?
Yes, sir.
And you compared those prints to those documents?
That's correct.
I'll show you what I've marked as State's Exhibits number 86, 87, and 88. And I'll ask you if those are the judgments that you're talking about.
Yes, sir. It's all three of them.
All right, let's start with well, I guess I need to admit them. Your Honor, at this time, do this. Yeah. Well, I'll admit states or offer States 87, 88, 86, 87 and 88 as certified documents, Judge, and I'm tendering the defense counsel for his inspection.
Those are the problem.
Yes.
Objections.
86, 87, and 88 are admitted.
Let's start with 88, please, Investigator Hinton. Well, you got a copy of it there, right?
I do. I don't know which exhibit they are, but
88
I
is
can mark them.
this cause number.
398.
And then 86 is this cause number.
6.
And of course, 87 will be the last of. If we could, I can direct your attention to States 88. What type of offense are we looking at there?
That's going to be evading arrest in a motor vehicle.
Is that a misdemeanor or a felony offense in the state of Texas?
That's a felony offense, third-degree felony.
And what is the cause number on that particular judgment?
Cause number is F22-3098-462.
And what county is that out of?
That's going to be in the 462nd District Court of Denton County, Texas.
Okay. And what was the disposition in that particular case?
Guilty.
And was the defendant, I guess what I'm getting at is, at least according to the judgment, was the defendant sent to prison or was the defendant placed on probation?
He was placed on 3 years deferred probation and $500 fine.
And I think I got a little bit ahead of myself. I did not exactly ask you whether or not you were able to use the fingerprint from that judgment to link it to this defendant.
I use that one again to make sure that's the print. Yes, I used this print. It exhibited very unique deltas. There's one on both sides of the core, and there was 3 other ending ridges. which are identical to the known print that I took. And because of the pixelation of this one, that's the only, so it's total 6, 5.
Let's unpack that a little bit. I mean, during your training experience, what are you looking for when you're comparing prints? You mentioned deltas and ridges. Explain to the jury what you're looking for.
I'm looking for characteristics. Some people call them points, is where they occupy on a known print, where they occupy the same space that they would occupy in a different print. So you can make the comparison between the two, determine if they're one and the same.
I mean, this is not just like throwing a dart at a dartboard. I mean, there is an art or a science, right?
There is, yes.
To doing this, correct?
Absolutely.
And is that method that you are trained in and that you used in this case, is that method widely accepted and used by law enforcement throughout the country?
It is, yes.
And did you use any special equipment to help enhance or magnify these prints so that you can make the comparison?
We do have magnifiers to be able to pull them up so they can be more readily visible.
And is it your testimony here today that you found sufficient enough points or ridges, or what was the other term you used?
There was 2 deltas, one on each side of the core, and there was 3 ending ridges. But because of the pixelation of this particular one, that's the only 5 that I'm really comfortable with identifying. That in conjunction, of course, with the SID, the state identification number and the name.
So for that felony offense of evading arrest, out of Denton County, for which the defendant received probation, you are comfortable that it's linked to this defendant, Joseph Charles Freeman, by virtue of his fingerprint on that?
Yes, sir.
What was the date? What would have been the date that he received that 3 years of deferred adjudication probation?
Date of offense was 7/28 of 2022.
So he would have been on probation, given that offense date. Well, do you have a judgment date when he received the probation? It may say sentence date on the first.
It showed date proceedings was deferred on October 27th, 2022.
So October of 2022. And you understand that the offense date for this particular case is in March of 2022, March 27th of 2022, more specifically.
Yes.
Okay. Let's move on to State's Exhibit number 86. What type of offense is that we're dealing with?
This is going to be a judgment of conviction by the court for aggravated robbery.
In your law enforcement training experience, typically, what is an aggravated robbery?
Aggravated usually means that there was a device used that is capable of committing serious bodily injury or death.
And in this case, if you look about midway down that first page of the judgment, does it indicate whether or not a deadly weapon was used and the type of deadly weapon?
Yeah, it shows the findings on deadly weapon as yes, there was a firearm used in this particular offense.
Well, at least according to this aggravated robbery judgment, the individual convicted of this offense used a firearm in the commission of that offense, correct?
That's correct.
All right, let's work our way down through this. What is the cause number on that one, please?
Cause number is going to be F2239679-0.
Out of what county, please?
That's going to be in Jefferson County and 252nd District Court.
Now, this particular judgment does not have a usable fingerprint on it, right?
No, it does not.
So how were you able to link this, if you were able to link it to this defendant, how were you able to do so?
With the name and the SID number, state identification number.
So the name that appears on here is Joseph Charles Freeman, right?
Correct.
And the state ID number, what is that, please?
It's a number.
No. I think they already got that from Captain Ponder. What it is, the type number. What I'm getting at is what's the actual number on the judgment, please?
Oh, I got you. State ID number is 195-03322.
Does that state ID number match the SID number on the booking records?
It does.
Does it match the SID number on that evading arrest probation order that you were able to confirm the fingerprint on.
It does.
Let's work our way down through this a little bit more. What's shown to be the date of offense on this one?
Shows March 19th, 2022.
So it would have preceded the March 27th, 2022 offense date in this case by a few days, right?
That's correct.
What was the sentence in that particular reflected in that judgment?
The sentence was for 60 years in the institutional division of the Texas Department of Criminal Justice.
60 years in prison.
60, yes, sir.
Let's move on to State's Exhibit number 87, please. State's Exhibit number 87. Let's just kind of shorten this a little bit. Is it fair to say it's for the same type of offense, aggravated robbery?
It's for the aggravated robbery, yes, sir. Committed on the same day.
Committed on the same day.
Second
And
robbery, yes.
And it's out of the same court, the 252nd District Court of Jefferson County, right?
That is correct.
And it is likewise for a 60-year sentence as well, right?
It is, yes.
And did you use the SID number to connect it to this defendant as well?
That's correct.
Again, because there was no usable print connected to this.
On this one, yes.
Now, based on your training and your law enforcement experience, if there is two separate judgments with two separate cause numbers from the same day with the same concurrent prison sentence, what does that tell you?
That's two separate events.
Or at least two separate
Offenses.
I kind of stepped in a little. At least two separate instances or two separate victims, right?
Correct.
Okay.
Cause number on Exhibit 87 is going to be F22-40981-0.
Thanks for making sure I put that up. Oh, you put that on the record. I appreciate that. Let me gather up these exhibits, and I think that's going to be all the questions I have for you. I'll pass the witness to you.
Thank you, Mr. Coleman. Mr. Bradford?
Mr. Hinton, I just have one question.
Yes, sir.
May I approach?
Yes, ma'am.
These judgment and sentences, those represent pleas of guilty, don't they? And they're not jury trials.
They are. They're all pleas of guilty, yes.
That's all I have.
Any other questions, Mr. Coleman?
No, Judge.
Any objection to Investigator Hinton being excused?
No, yeah.
Thank you, sir.
Stay rest at this time, Judge.
Thank you,
The
Mr.
punishment phase has now reached its conclusion. After considering the evidence presented by both sides, including the defendant's criminal history and the arguments made during closing statements, the jury assessed Joseph Charles Freeman's punishment at 60 years in the Texas Department of Criminal Justice with no fine. Judge Raquel West formally pronounced the sentence in accordance with the jury's unanimous verdict, awarded credit for time already served as required by law, advised the defendant of his appellate rights, and ordered that he remain in custody pending transfer to the Texas Department of Criminal Justice. This hearing illustrates that once a defendant has been found guilty, the punishment phase becomes a separate and equally important legal proceeding where the jury weighs statutory sentencing factors before determining the final penalty. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't